Hello, welcome to 39 Essex Chambers and today's webinar entitled COVID-19 Business Interruption Insurance, the High Court Guidance in the FCA Test Case. My name is Michael McParland and I'll be our panel chairman today. Over the next 45 minutes, the panel will be discussing last week's decision in the case of the FCA against Arch Insurance and others, in which, as you know, Lord Justice Flo and Mr. Justice Butcher determined a series of issues of principle in relation to policy coverage in respect of specimen wordings regarding business interruption losses as a consequence of the COVID-19 pandemic and the advice and restrictions imposed by the UK government as a consequence of the pandemic. As you know, for yourselves, and there's many hundreds of you have joined today, so I'm very pleased to see that. For 39 Essex Chambers, the question of business interruption coverage has been a major area of concern for our clients. And we've done a number of previous webinar materials regarding this. In particular, on 2nd of June, we produced a webinar entitled Business Interruption Insurance in the Time of Corona. The devil is in the policy wording, which is ever a proper guidance for it now. And that's available on our website. It focused on the extension cover for notifiable diseases, for non-damage denial of access and causation of recoverable losses. All the materials are there in our webinar archives if you want to follow that on up. I'm very pleased today that we have two of the speakers from that webinar on our panel. The first is Neil Block, Queen's Counsel, who barely needs no introduction to the insurance market, but there he is giving a wave. Neil, as you know, was called to the bar in 1980 and took silk in 2002. He has a wide-ranging practice acting mainly for insurers, large institutions, and the government. He regularly advises on a range of insurance coverage issues and has recently advised regulators, insurers, and policyholders of business interruption and other COVID-19 related issues. And above him, in blue rather than in pink, is Jonathan Bellamy, whose work in insurance and reinsurance practice comprises litigation, arbitration, and advice as counsel. This work covers all issues relating to policy interpretation and coverage relating to the full range of indemnity and contingency policies, and indeed financial line covers. He has extensive experience of business interruption claims before and after our current pandemic. His experience includes policies governed by recognized civil law systems and other common law systems. He also has an active practice of chartered arbitration in this sector. I must begin by an apology. We are a person light. Marion Smith, QC, who was scheduled to join us, has been unfortunately unavoidably detained, and she sends our apologies. Now, a bit of housekeeping. The format today is a roundtable Q&A regarding some of the key issues that arose in the judgment. Obviously, it's a complex judgment, and today is but an introduction. Subsequent to this webinar, 39 Essex will be producing a series of podcasts that deals in greater detail with some of the central issues and discusses what the case means for market participants and policyholders. We hope you'll be able to join us on those podcasts in due course. This webinar will be recorded and subsequently made available from 39 Chambers, Essex Chambers website in case any of your colleagues have missed it. And for those of you, they used to say that death and taxes were the only certainties in life, but of course in professional life, there's also continuing professional development hours to be clocked up. So if you aren't doing those, the CPD provider is 39 Essex Chambers. As you'll see from the Q&A at the bottom, we will hope to be able to have some time available towards the end of the webinar to deal with some of your questions. Obviously, general questions that don't hinge on specific wordings may be easier to handle. Now, as you all know, in this case, in the FCA case, the FCA brought forward consideration of 21 lead policies issued by 8 insurers, but they estimated that some 700 types of policies across 60 different insurers and 370,000 policyholders could potentially be affected by the test case. Now, this webinar is divided into the 3 categories that were adopted by the FCA and the court as regard the type of clauses involved. And the first one we're going to turn to is disease clauses. This is the non-damage extensions to the standard business interruption cover provided by the relevant insurers. Of course, as you all know, standard cover is of course contingent on the occurrence of physical or material damage to the insured premises. This extension to cover the non-damaged by consequence of disease is, of course, what the whole of this application was about. Now, the FCA case considered policies issued by 4 insurers, RSA, Argenta, MS Amlin, and QBE. Now, while the wording differed in each case, they all provided cover for interruption or interference with the business, following, arising from, as a result of, any notifiable disease, occurrence of a notifiable diseases arising from any human infectious or human contagious disease manifested by any person, crucially, within 25 miles or 1 mile or the vicinity of the premises insured in location. So one of the most important issues that arises out of this judgment is how did the court deal with the limits these sort of policies put on it? Now, I'd like to start by raising a question regarding what is known in the case as policy RSA3, which provided for interruption or interference with the business during the indemnity period following, that's the key word, any occurrence of a notifiable disease within a radius of 25 miles of the premises. Now, the court had to consider what the word following meant, and in particular, did it mean that had to be a proximate cause, the disease had to be a proximate cause of the disruption. So I'm going to ask Jonathan first. How did the court reach its conclusion? And frankly, are you convinced by its approach?
Michael, thank you very much for the introduction and for setting out the generalities of the case. The first point is that, to remind ourselves, is that there was agreement between all counsel and all parties on general principles of contractual construction in this case. That's really not surprising, given all the attention that those points have received in the Supreme Court in the last 5 or 6 years. But that's the case. One then has the phrase which comes out of paragraph 95 of the judgment, which I think is worth bearing in mind, given the way that the court approached this particular point. They said that, quotes, the courts tend to avoid drawing nice distinctions between causative phrases in an insurance contract, end quote. Now, the problem is that really that's exactly what they did in this case. They drew a distinction, in effect, on the one hand between following, and on the other hand, between arising from or in connection with. Now, we all know that insurance contracts have their own particular rationale and reason for those linked words. But bear in mind that Section 55(1) of the Marine Insurance Act 1906 starts with a pretty strong premise that it should be proximate cause, unless the policy provides otherwise. One is left really wondering why the word following was so different. So, for one, I'm not quite so sure that it was a decision that's easily justifiable on the basis that was given.
Neil, now taking Jonathan's point that, the case law says that proximate cause is not the cause nearest in time to the loss, but the efficient or dominant cause. That's the old torpedo case, the Leyland shipping case. Now, do you think that the court could justify considering that a looser causal relationship than the concept of proximate cause could be attributable to these policies, in the words following?
I think thanks, Michael. Just as a preliminary point, we can't lose sight of the fact, as the court points out, that although there are 21 policies they're looking at, they think that the judgment will be applied by lawyers to over 700 different policies. They all have slightly different wording, and it seems to me that they are trying to give guidance as to a way through that, from the policyholder's point of view, is fair, reasonable, and logical. And against that background, with Jonathan's point, I think that the court was grappling with the fact that, first of all, most of the policies require there to be a person who has either been diagnosed or is showing signs or symptoms of COVID within the radius. That is the gateway, the policy gateway for a claim. But having done that, the policy then allows a claim where COVID is the indirect cause. In other words, the national pandemic applies. And if one were trying to apply proximate cause to indirect causes, all kinds of problems might follow. And it's my view that that's why the court has taken the approach that it has. And I suspect that the reasonable subjective view would be that a policyholder would expect that approach.
Okay. Well, but part of the dispute in RSA3 was about the trends clause, which was attached to the policy. Now, my next question, really, I'll start with you, if I may, Neil, is that the insurers argue that the trends clause should be interpreted to include components of the insured peril itself, and accordingly it should be applied in a way which effectively negated the value of any insurance cover available to the insured. Now, how did the court resolve this, and were you sort of convinced by it?
Well, the first point to make is that notwithstanding the quite wide variety of wording of the trends clauses that were looked at, the court was able to bring them all under the umbrella of one very consistent approach. And that is that one, when cover has been established, one then looks at what the business would have received in income in any event if COVID had not existed, and compares that to the present situation. And I think that that's a fair and logical approach, because the alternative approach, and we'll look at it when we come on to causation, is that one simply looks at COVID everywhere else except for, in other words, the indirect COVID as opposed to the direct COVID, and says, well, the business wouldn't have been able to function even if the direct COVID consequence was modest.
Jonathan, well, the court was taking the view in relation to trends that once an insured has established a prima facie loss, it would seem contrary in principle, unless the policy wording so required, for that loss to be limited by the inclusion of any part of the insured peril in assessing the role of the trends clause. Do you think that's sustainable?
I do. I think I agree with Neil on this point. I think that the question you've raised there is a very important one. In my own view, if you look into this very long judgment, and in a number of ways they set out what they describe as common themes, that's the phrase they use. Structure of the judgment is to take the various sections, apply certain, or discuss and resolve certain points of principle, then go on to the policy wording. Sometimes you find the important points of common theme within the wording discussion, and this is an example of that. One of the phrases they use is that it would be, quote, commercially surprising, unquote, in their view, the court's view, if the result were otherwise. And I think that the single theme that I see running through this whole judgment is that there shouldn't be illusory cover. That's a phrase, I'm using that phrase because the judges use it on a number of different occasions, in a number of different ways. So where I think, to use Neil's phrase, that there's a common theme here, although it's taken from different points, is that the insurance policy shouldn't be allowed to give with one hand and take away with the other. And I think if and when, and it is an if in many cases, this exceptional, let's remind ourselves it's always an exceptional form of cover is proved, then it would be wrong to take it away. The simplest analogy being the one used during the discussion of the Orient Express case, where you have the paradox, as the commentator said before this judgment on Orient Express, that the policyholder is in a worse position if the hurricane is a very severe consequence than if he's not.
Well, before we leave trends, you can see, trend clauses, you can see the court sort of manipulating the language in relation to those clauses that were drafted to apply to losses from damage. Now, on their face, they did not apply to non-damage extensions. the policy, but the court concluded it must have been intended that the clauses would apply to non-damage extensions. Neil, do you think that's the right way to approach it?
I think when I first read it, I was quite surprised because it's not the court's job to rewrite the policies, but to construe them. But on giving it further thought, it seemed to me logical not to distinguish between damage and non-damage. And in many ways, the trends clause and the interpretation that's been given to it now, the trends clause has very little value in addition to the common law, because what the court is saying is that you have to put the party in the position it would have been in if the insured peril had not occurred. And that is, of course, the common law position. There are some interesting refinements, though, because, for example, in those policies in which the cover only begins at the point where the disease is notifiable, which in this case was relatively late in March as opposed to when it was known of, which went back months, then the trend clause would apply, so that it's only from the date that the disease became notifiable that one is looking at the losses. So if there were pre-notifiable losses as a result of COVID, people started being more cautious about going out as far as, say, restaurants were concerned, then that was a trend that has to be taken into account, as opposed to the post-notification trend, which has to be ignored because that results from the insured peril, which in that case is the notifiable disease. So I think there's logic in it.
Good. I'm going to move on to the second of the RSA policy, RS4, because it has my favorite bit, the interpretation of the word vicinity. Now, the policy, which is a RSA marsh resilience wording, provided cover for in the event of interruption or interference to the insured's business as a result of occurring within the vicinity of an insured location during the period of insurance. That's notifiable diseases. Now, vicinity was expressly defined as an area surrounding or adjacent to an insured location in which events that occur within such area would be reasonably expected to have an impact on insured or the insured's business. Now, my question, Jonathan, is this: the court adopted a wide construction of this clause, an interpretation of the word vicinity, so that ultimately vicinity included England and Wales.
And Michael, not just England and Wales, because one of the really interesting points that comes out of this is why England and Wales? Why not Scotland?
Yeah, I did want.
But why not the world?
Maybe they're anticipating developments north of the border, which haven't yet been reached. No,
yes.
Yeah.
To pick up your point, Michael, it's well made, because firstly, you've got a defined term. Secondly, this is, I think, the only part in this judgment where the court used the phrase, when construing the clause, the reasonable man. Now, that is itself not really a piece of terminology one uses in contractual construction. It's much more familiar in tort law for other reasons. And to me, again, the way this is to be explained is to avoid illusory cover. Because what they've done here in this decision is the judges have sought to find a meaning for what Neil described earlier, and I think correctly, as indirect causation, where you've got an effect within the vicinity, if you like, of the COVID-19 virus. So it's quite hard to justify this and quite hard to see where the boundaries are, because the litmus test which they've applied is in effect an origin, an area which can affect the business, which is the subject matter of the schedule at the point of contracting. And that can be very wide indeed, not necessarily limited to Berwick-on-Tweed.
Well, poor old Berwick-on-Tweed. Now, Neil, what do you think of that?
Well, I think that the approach of the court is governed by a conclusion that COVID is an indivisible disease. And by that, I don't mean divisible into the component parts of the disease, but nationally it's indivisible. and that the gateway, as I said earlier, is that at least one individual, and we can talk about how that's proven later if we have time, but at least one individual within the defined area, whether it's 1 mile in some policies, 25 miles, or the vicinity, one individual has either been diagnosed or manifests symptoms. And then is that part of a greater whole? And if the answer is yes, then I think the court says, well, it's artificial to say for London, well, that ends at the M25 as opposed to at the coast. And
now, that leads me on, because the insurers were arguing that the policy words themselves, area surrounding or adjacent to, suggested, to use their phrase, close spatial proximity to the premises. Now, what falls within the insured peril must happen inside and not beyond the vicinity. And it's only that which happens inside the vicinity which must proximately cause the relevant business interruption for it to be covered. Now, what do you make of those more restrictive arguments?
Well, it's interesting because when we come to look at prevention of access, we see the court actually takes, on some wording, a much more restrictive approach because the trigger in those policies is an event or words similar to that. And the court said, well, that's very different because an event is something that has to be pinpointed and for example, the policy is designed to cover restriction of access for a bomb threat or the like. But here we have much wider wording, and I think that encouraged the court to take the wider approach to vicinity.
Well, Jonathan, the court considered in the alternative, if they were wrong and they had to adopt the insurer's interpretation of the meaning of vicinity, they thought it would not be correct to confine the cover to the effects of a disease occurring only within the vicinity, nor its views either expressly or implicitly confined to the effects only of the cases of the disease within the vicinity. Instead, they took the view that the wording was such that it covered the effects of a notifiable disease which has come within the vicinity. Now, are we dealing with something of angels on the heads of pins here now?
Well, it's a difficult one, isn't it, Michael? Because the vicinity's got to have a meaning, and one goes back to the purposes of these clauses themselves. They are disease clauses. The vicinity, as I say, must have some form of limitation on the cover. I think the court are on difficult ground on this one, I must say. I think they probably, if this were to go to any form of appeal over direct or leapfrog, I think on this one, the decision's vulnerable. I think that they can seek to extend with one hand about the concept of vicinity and restrict on the other by interpreting incident and event as different from, quote, state of affairs or emergency. But I think on this one, it's difficult to sustain myself.
Now let's move on to the question of causation and a spot of murder on the Orient Express, which the Orient Express case of Orient Express Hotels Limited against Acquisizioni Generali SPA 2010 EWHC 1186 commercial featured prominently in the insurer's case on both causation and the trends clause. Now, Neil, can you tell us about the Orient Express, that sad hotel in New Orleans?
I certainly can, and I would just say before giving a brief summary of the case that when we had our first seminar, I indicated that I felt that the reasoning was vulnerable, but I suspected that it would take a case in the Court of Appeal to demonstrate that vulnerability. But in fact, we have a divisional court in effect here, proving the vulnerability. This was a claim that arose in the aftermath of Hurricanes Katrina and Rita in the New Orleans in 2005. The claimant hotel had the benefit of an insurance policy which covered business interruption directly arising from damage. That's a quotation. And damage was defined as direct physical loss, destruction, or damage to the hotel. There was a trends clause in the policy, and that provided for variations or special circumstances that would have affected the hotel business had the hotel not been damaged to be taken into account. And the policy was governed by English law. Now, the hotel had suffered significant damage in the hurricane, and it was agreed that this damage to the hotel had caused interruption to the business of running a hotel, and it had closed for about 2 months whilst the repair works were carried out. But during that period, the surrounding area was devastated by the hurricanes, with the entire city of New Orleans being shut down for several weeks following a declaration of emergency, the imposition of a curfew, and a mandatory evacuation. And so the issue that arose was whether the interruption of business by reason of damage to the hotel was the cause of the hotel's loss of income within the meaning of the policy. And the insurer argued that the policy only covered loss that the insured could prove wouldn't have arisen but for the interruption of its business due to the damage of the hotel premises, and that because the business would have been impossible because of the local damage and the curfew, etc., then no loss arose. This was an arbitration. The arbitrators accepted the insurer's argument and no award was made. There was an appeal to Hamlin J in the commercial court, and he considered whether the but-for test should apply. There was argument relying in particular on the relaxation of the but-for case in the Kuwaiti Airways case, but to cut a long story short, he didn't accept that the arbitrator had made a mistake of law and upheld the decision. And from that time, academics and practitioners have criticized the decision, and as Jonathan alluded to, they argued that in effect, the worse the damage, the less likelihood there would be ever of a recovery. So if the hotel had been the only thing damaged in that hurricane, then there would have been a recovery. But because the damage was more widespread, then there was no recovery. As I'm sure that you've all gathered from the way I've introduced Orient Express, the judges took a different view in the recent case, and they did not consider that it was appropriate to apply the but-for test in circumstances such as this, and that the court, Hamlin J, his mistake probably was to approach the matter by looking at the but-for test rather than looking at what was the insured peril. And if he had approached it by looking at what was the insured peril, he would have concluded the insured peril was damage caused by hurricane, and therefore would have found that there was a loss, even if there was a concurrent cause in that there was more widespread damage.
Thanks, Neil. Now, Jonathan, they distinguished Orient Express by one of the things, the type of insurance that was in issue in this case. Now, but they would have said they wouldn't have followed it, not least because of the imposition of the but-for test, which is a tort test, into what is a well-defined contractual relationship in insurance. Do you agree with that approach?
Well, I think that one of the most interesting things about this part of the case, paragraph 503, they do 82 pages of counsel's skeleton arguments in the paragraph, which, you know, we've all been in similar situations. We're dispiriting when it happens, though. Because what they say, and again, stepping back to the beginning of this analysis, is that in this case they found, and dare I say it in most cases, issues of causation are normally defined by my analysis of what the insured peril is. Now, I think the second interesting point about this is that one of the arbitration panel in the Orient Express case is now a Supreme Court judge. The judge in Orient Express is now a Supreme Court judge. And the interesting point about that is that it came on a Section 69 application under the Arbitration Act. So what Mr. Justice Hamlin was having to do actually was to consider the answers given by the arbitration panel to the questions that it had resolved to decide. So it wasn't an open playing field on that basis. Now, I'm not quite so surprised that they didn't follow Orient Express, given, as Neil said, some of the academic commentary on it. I am slightly surprised that they went into it in such detail, given what they'd already said, almost teeing it up for some sort of Supreme Court treatment in this particular case. Finally, on this point from me, I find it interesting that it takes a 165-page judgment to remind us what Section 55 of the Marine Insurance Act 1906 says. And as you said earlier, Michael, Leyland Shipping, which goes back right to the beginning of the 20th century. Yeah, well, so there's never any harm, is there, in going back to basics?
As they always say, sometimes we need to be reminded. Neil, now on the question, one of the things that runs through the judgment, both regards the RS3A and 3 and 4 policies, was that the issues of causation are largely answered by the construction to be placed on the cover provided. Are you happy with that sort of cutting the Gordian knot of causation by just treating it all ultimately as a question of policy construction?
Well, I think that's against the background of, although causation is dealt with as the penultimate topic in the 162-page judgment, the final topic being what evidence is required. Very early in the judgment, the judges made it clear that proximate cause would often be the test, but they weren't even applying that to following. But when they then come to deal with causation, they look very much at proximate cause. In paragraph 525, they say, if the question had been asked what was the proximate cause of the loss claimed, it seems to us that the correct answer would not have been business interruption arising from damage in the abstract, but business interruption arising from damage caused by the hurricanes as a covered fortuity. And to my mind, whilst proximate cause is looked at as a backstop earlier in the judgment when interpreting the meaning of following, it comes very much into focus when looking at causation. And so I think you need to read the judgment twice. You need to get as far as causation and then go back and start again. And I think it does all fall into place. I suspect that it is sufficiently watertight on causation, and that if there are appeals, they are more likely to be on the individual wording as to the triggers for cover.
I should say that the word on the street, as they say, about questions of appeals is, of course, there's going to be a consequential hearing on the 2nd of October. And if there is going to be appeal, it's likely to be a leapfrog appeal to the Supreme Court to be heard at the end of this year. Now, that seems to be the latest information we can get. But I'd like to move on to the second kind of policy now, leaving diseases alone and moving on to prevention of access and public authorities' wordings. Now, as you know, these provisions provide cover where there's been a prevention or hindrance of access to or use of the premises as a consequence of government or other public authority action or restrictions. Now, the policies in question provided cover for loss resulting from, quote, prevention or denial or hindrance of access to the premises, which was due to actions, advice, restrictions of, imposed by order of a government, local authority, police, or other body due to an emergency likely to endanger life, neighbouring property or incident within a specified area. Now, of anything, these are all very fact-specific, wording-specific issues that have to be resolved. So at this stage, can I just ask you a general question? Now, the court considered that in general, these kinds of prevention of access, public authority intervention wording should be more restrictively interpreted than the majority of disease clauses. Now, Jonathan, are you convinced by the court's analysis of this?
Well, I think the first thing to say is essentially I am, for this reason, that disease extensions, disease clauses are, unsurprisingly, designed to address disease. That's what I get paid for, to write things like that down sometimes. But the prevention of access, the non-damage denial and access clauses, are not necessarily disease clauses. They may be disease clauses, but they naturally lend themselves to other things which we all know about, such as terrorist attacks and police cordons and that sort of thing. And so I'm not that surprised standing back from it before one even begins to consider construction of wording and stem clauses and this sort of thing, that the courts have been a bit stricter on it. I'm also not surprised that they have been strict on only finding as a trigger legally binding obligations under the 21 and 26 March regulations, and not simply what the Prime Minister says outside 10 Downing Street.
Which, as you can see from this lunchtime, changes almost by the day. Neil, what do you feel about these more restrictive interpretations?
I generally agree with Jonathan. Some quite nice exam questions come out of this. So, for example, if a business is, such as a restaurant, is prevented by law from operating as a sit-down restaurant, but permitted to serve takeaway food, if it served takeaway food in addition to its sit-down restaurant service beforehand and continues to do so, then there is no prevention of access within the cover. If, on the other hand, as a result of not being able to serve meals within the restaurant, the owners make an entrepreneurial decision to change their business and to start serving takeaway food, then they do come within the cover, because access for the purposes of the business as it was at the time that the policy was taken out is the relevant consideration. So I think it's logical. It does create a hardship for business A over business B, but there have to be black lines somewhere, because we've already had a number of questions asking, well, following the judgment, what can I do for my policyholder client? And I think it's important that the prevention of access clause in particular can be looked at and some positive advice can be given.
Good.
To chip in there, Michael, let's also remember that under a number of these non-damage denial of access clauses, the sub-limits are quite low. And so it doesn't suit the long-term interests of the business to sit on its hands and not, as Neil said, develop a takeaway business, or in one of the other examples given in the case, the theatre company that puts plays online. In one way, it can seem harsh, but then again, an insurance policy like this is just one of the tools of risk management, isn't it, for an enterprise? It's got to look to its long-term business and goodwill, really.
Yeah, and also, Jonathan, it's interesting that on the point that you've made, that one has to be prevented by law from accessing the premises, a huge number of professional practices have in fact closed, and I suspect a great number of our audience can identify with that. So if accountant's practice, a solicitor's practice, or whatever, those practices are not prevented by law from operating from their offices, and therefore they cannot claim under their business interruption policies, even if their businesses are being devastated by the effects of the government guidance.
Well, that's absolutely right, and that's what they say that in in the judgment as a Category 5 case. They included professional services firms and construction companies. This, of course, gives us a great opportunity to say that 39 Essex chambers remain open throughout and remains open even before the podcast, which we're going to drop on you.
Special thank you to all the staff for doing that, keeping us afloat.
Yes,
in troubled times.
absolutely.
I'd like to move on to the final policy area. It's the hybrid wordings. Now, those are clauses which represent a mix of the disease clause and prevention of access clauses. Now, broadly, they covered losses resulting from an interruption to the business due to the inability to use the premises, due to restrictions imposed by a public authority following an occurrence of a disease. Now, if I can ask you both in 30 seconds, how did the court resolve the tension between the relatively broad interpretation given to the disease clauses and the more restrictive approach adopted in relation to prevention of access clauses? Neil, you're starting at 10.
The glib answer is they looked at the different wording in the different policies and then interpreted accordingly. But in practice, the hybrid clauses, I think, generally were probably treated more favourably for the insurers in a narrower interpretation than the disease clauses.
Jonathan?
Just to add, I have personally, of the ones that I've seen in practice, I've seen fewer of these than any other. I think I agree with Neil principally for this reason, because it's not an either or. The hybrid is both. So in a sense, the hurdle which the policy has set is you've got to satisfy both the considerations of a disease clause and those of a non-damage denial of access. So I'm not that surprised they've taken a stricter approach.
Right. Now we're coming to near the end of our time, and as I said, we'll be following up these matters with podcasts that detail the specific issues in greater detail. But people have been kindly sending us in Q&A questions. I've seen the numbers change as we go on. Are there any of the questions that you, Jonathan, would like to comment on?
Well, I've done my best to keep an eye on them as they come in. They're numerous and they're interesting. Almost all of them deal with Orient Express, interestingly enough. And that appears to be the real interest from those participants who wish to go to Q&A. One or two of them are very case specific, they're very factual and relate to certain given sets of facts, which probably wouldn't be of great interest to the overwhelming majority of participants. So I think I can pretty confidently say in the time that we've used, the 45 minutes we've had, that we've really answered all those ones that have been raised.
I hope so. Neil, your thoughts?
Yes, I'd just say that it seems to me that we're being invited to criticise the narrow approach in Orient Express being widened by this court. But personally, I doubted that Orient Express would survive the close consideration of the courts in this country, because it is just illogical that the more widespread the damage, the less likely it is that one would make a recovery under the policy, when the policyholder would no doubt think the absolute opposite.
Now we've reached our time, our allotted time that we said we would keep you. I'm very grateful to see the huge number of participants have stayed with us. Thank you very much on this day. I'd like to say that, as I said before, come back and see us on the website as regards podcasts and the other matters relating to these matters. But from Jonathan, it's goodbye from you.
And goodbye from you.
And goodbye, Neil, from you too. And from me, Michael McParland, I wish you all the best. Keep safe in these troubled times. Take care all.
All right.
Thank you. Goodbye.